Good afternoon, everyone, and welcome to another episode of Fides et Politica. It's a pleasure to have you all here. We've been gone for a week on vacation, but we're back for another really exciting episode on some of the latest developments that we've been following in the U.S. Supreme Court. And we're also going to talk a little bit about what's been kind of raving on the news, which was the quote-unquote big, beautiful bill. I'm joined here. I'm Glenn Brazil de Souza, and I'm joined here with my co-host, Nick Miller.
Yes, Nick Miller from Washington Adventist University, from the Honors College, where I help direct the Center for Law and Public Policy. This week actually finds me at Andrews University, and I'm still a professor of church history at Andrews University, help run an International Religious Liberty Institute, and I'm meeting with some of the leaders here. But it's a good time. I've been following from a distance developments in Washington and at the U.S. Supreme Court, and we've had a couple of really pretty significant decisions regarding presidential power versus judicial power and birthright citizenship, and then a very important case about the right of parents to educate their children in terms of their own religious values, especially as regards sexuality and gender. So Guilherme is going to lead out in an interview on these issues.
No, fantastic, Nick. And we saw these three cases that came up in this last term of the U.S. Supreme Court. They were Trump v. CASA, the one dealing with birthright citizenship; Mahmoud v. Taylor, the one dealing with the right of parents to opt out of LGBTQ and quote-unquote inclusive storybooks. And also we had a Free Speech Coalition Inc. v. Paxton. I think all of these, in one way or another, they touch on a theme that we've been talking here a lot on the podcast, which is the free church tradition. And we're going to see a little bit more of this. And we're privileged that we have you, Nick, who's a specialist in First Amendment law and who's written a book on the history of the First Amendment. And I think we're going to have, I think, a very interesting conversation. I want to start us off by first reading with the 14th Amendment. We're going to start off with Trump v. CASA Inc. This was a case dealing with how lower courts should handle President Trump's executive order, which declared that the children of parents who entered the U.S. illegally or on a temporary visa are not entitled to automatic citizenship. So the 14th Amendment, for those of us who might not know, it was enacted by Congress in 1868 following the U.S. Civil War, and it had a very revolutionary provision that says in Section 1, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law. So I think to start us off, Nick, given your specialty in constitutional law, tell us a little bit, what was the issue that was at play here? We know that this case had dealt with a universal injunction. Tell us a little bit about what is a universal injunction and what were some of the consequences of this case for universal injunctions pertaining to the 14th Amendment.
So, yes, to begin with, this has to do with an executive order of President Trump, where he declared through executive order that despite the language of the 14th Amendment, that children born to parents who are undocumented, who did not enter or stayed within the U.S. unlawfully, or even if they're here on a temporary visa, that they're not entitled, the children are not entitled to automatic citizenship. So it's been called birthright citizenship. This was, of course, very quickly challenged in federal court because, as you read the amendment, the very first part of the amendment says all persons born or naturalized in the United States are citizens of the US. So President Trump's executive order seems to go directly contrary to a provision of the Constitution, as well as it's been understood and interpreted by the Congress and courts since the beginning of our country. So he was challenged in federal courts in more than one case. And this is where it gets tricky, because one judge said what President Trump did was unconstitutional, which isn't a surprising result. But then what he did was he enjoined the president's order nationwide. And to understand the significance of this, you have to understand the federal court system, right? Each state has at least one and sometimes more than one federal districts within it that the trial courts will oversee. So usually a federal court's decision will only apply to the parties before it and possibly to the jurisdiction in which the court is located, sometimes up to an entire state. And then there are courts of appeals where you can appeal to the Ninth Circuit or the 11th Circuit, which is a collection of states. And then the decision of that court will bind everybody in those few states. In rare cases, a single judge at the local level can issue a nationwide injunction. And that's what happened here.
Are there criteria for that?
Well, so yes, there are. It has to deal with a case of nationwide significance, of significant constitutional importance. I mean, there's standards that need to be met, but even if those standards are met, there's some question as to whether a single, how many federal judges are there? I believe somewhere in the 700 or 800s.
Right.
So if you disagree with a president's order, you can shop around and find a federal judge somewhere who will be seriously willing to consider turning it over or enjoining it. And then you have one judge undoing the law for the entire country. And even if you agree that birthright citizenship should be defended and supported, and the president's order is probably unlawful and unconstitutional, you can also agree that it might be problematic to have that law enjoined for the whole country by one single federal judge. And in fact, that's what the Supreme Court ruled, that that the judge exceeded his authority. As Amy Coney Barrett said for the majority, universal injunctions likely exceed the equitable authority that Congress has given to the federal courts. So some people read this decision as, supporting Trump in his overturning of birthright citizenship, but that's to misread the case. It wasn't about that. It was simply whether one judge could overturn the executive order for the entire country. So when the case is sent back down, that judge's ruling is still relevant and applicable for the case that he entered it in, and probably in the federal jurisdiction in which he sits. It's just that people in other jurisdictions are going to have to bring their cases to federal court, at least until it reaches the Supreme Court, right? Because the Supreme Court can knock the law down for the whole country. And likely that's what will happen next.
So just to put kind of things in perspective for our audience, maybe those who aren't so proficient in the law, the court didn't argue on the merits of Trump's executive order. It didn't say that whether it was constitutional or not. It just said for that judge in that specific location to enjoin that decision at a national level was beyond their jurisdiction, correct? Their authority.
That's right. That's right. So some headlines suggested, the Supreme Court upheld Trump's attack on birthright citizenship. Not true. What they did was say one federal judge can't make the decision for the entire country.
Right.
I think it's the dissent of Justice Jackson. It suggests that there's like a contest between an imperial judiciary versus an imperial executive. Can the judicial branch be too strong? And I think in this case, we see in what happened, a single judge invalidating a law for the entire country rather than just his jurisdiction and maybe even the parties before him, versus then a president whose right to enact executive orders can be prevented by a single judge. But on the other hand, what the President Trump is trying to do in this case by overturning a written clause of the Constitution shows the tendency towards an imperial executive branch.
Yeah.
And that's a problem too. And so this free church tradition that we're talking about believes in part that freedom for the people is achieved not just by having a list of good freedoms, but by having institutions that check and balance each other, and that no single institution is too strong, whether that be the president or the judiciary or even the Congress. Although under our Constitution, perhaps this is a question I should put to a foreigner, a Brazilian,
Yeah.
which branch of government is meant to be the strongest?
Oh, well, I think if well, yeah, since you asked should, right? And ideally, I would say it's the people, right? It's we, the people. So it should be the
Yeah,
legislature, the legislature. So we should have an imperial legislature as opposed to an imperial executive or an imperial judiciary. And that's something that I think the founders were very well aware of. You see with I don't know if it was Hamilton that talked about the tyranny of the judiciary, that wanted a weaker judicial branch because of the fears, which we see not only in the U.S. but in other places, like even Brazil. Like, kind of bring it to my own reality, where the judiciary, in the name of good motives, can overreach its proper function. But then there's, like you said, there's also the fear of a unitary executive, right? Which is something that can be very real and that we've seen become very real in the last 30 years. But I think what we really want is the people, and checked by a limited Bill of Rights that protects individual liberties from the tyranny of the majority.
yeah. Well, we don't want an imperial anything, I would
Yeah,
argue,
exactly.
right?
Yeah,
We don't want an imperial Congress either. What we
yeah,
want is a healthy and robust competing branches of government,
yeah,
competing and cooperating. But I do think that the founders, the first article of the Constitution is the article framing and forming the Congress,
the Congress. Yeah.
because the founders did view the Congress as being the most representative branch of the majority, and at least in between elections and in between constitutional conventions, it's Congress which most fully represents the will of the people and is meant to be the strongest branch to which the other branches are accountable, except in the rare and small areas of the Bill of Rights, which in fact the majority needs to respect and which the court system can speak on behalf of.
Hmm.
But
And maybe just to emphasize, the courts are to protect those rights and not necessarily to go beyond those that have been enumerated.
yes, and so there's a question about how far the court is allowed to interpret rights
Right.
to encompass beyond the. Anyway, I'm sure we'll get into that
Yeah.
in other
In
cases.
in our next conversation,
And
right? Because our next
is
topic has exactly to do with that, and that's Mahmoud v. Taylor. That's another case that was decided right in our backyard in Montgomery County, where both of us live in Maryland. Montgomery County, for those of you who don't know, it's one of the most religiously diverse. It is the most religiously diverse neighborhood in America, with the largest per capita number of Christians, Jews, Buddhists. And in this case, we had a very interesting scenario, which dealt with whether public schools burden the religious exercise of parents when they compel elementary school children to participate on instruction on gender and sexuality against the parents' religious convictions, and without notice or opportunity to opt out of those instructions. So just to maybe give a little bit more of the facts of the case, Montgomery County had a policy of these LGBTQ affirming books that were children's books, illustrated books that included stories of In one of the stories, you had an uncle of a child who was marrying another man, and it was presenting that relationship in a positive way. And then it raised this religious liberty issue of whether the parents have a right to not have their children participate in those reading sessions and in those instructions. So I wanted to ask. I know, Nick, you've published a lot in this area of family law and the intersections between family law and religious liberty and the rights of gay, lesbian, and trans persons. And I think this raises like a very important question that we've been seeing in the last 5 years. How do we evaluate this case? What rights do parents have? And how do we balance these rights with the rights of the state, if the state wants to promote a different definition of the family? What are your thoughts on that?
Well, so I think we need to acknowledge that the Supreme Court came to a majority decision that the parents should be able to opt out from these particular books and set of instructions. That this was an area where parental concerns and spiritual values should be respected and protected. And honestly, I think they came to the right decision.
Mm,
Um, it's a close call in that we probably would we want to have an opt out if there were a series of books that talked about racial inclusivity, that
yes.
talked about blacks and whites and Asians and Hispanics,
Or
being
interracial unions. I think that was something that was brought up.
interracial unions, or even being equal in society, equal before the law. I'm not sure we would be willing or wanting to allow members of the KKK or some other fringe hate groups to bring their children up without being exposed to this fundamental pluralism that lies at the heart of our nation. So why do I feel that it's appropriate here for the parental beliefs to be protected? And I just think we have to acknowledge that both historically and legally, there is a difference between issues of race, ethnicity, versus gender and sex.
Good.
Um,
Okay. Yeah.
you
Tell
know,
us more about that
well,
distinction.
so, you could say that the equality of humans before the law as being created by God is found in our Declaration of Independence, right? All men are created equal. Now, it doesn't say all men and women, but in that day and age, man was meant to be inclusive of humanity. And so there was a fundamental public policy commitment to the equality of all races. Um, and I think even though we had slavery at the time, you had an acknowledgement, even by slave owners, by Thomas Jefferson, who believed that slavery was wrong and contradicted the fundamental principles of religion as found in nature itself. And so, but you won't find that kind of allowance, if you will, in terms of alternate sexualities or alternate forms of marriage. I mean, there's nothing in our founding documents that kind of commits us to being neutral as regards to family units. And
Or in
and,
other
and to the
societies as well, right?
yeah, and to the contrary, we have a whole history of a deep level of protection of laws protecting family
Anti-sodomy.
units, laws against sexual misbehavior, laws protecting children from exposure to sexually explicit material. And this is not just a historical fact, but it's also a legal fact. Those that know something about constitutional rights, it is race and ethnicity are protected at the highest level of constitutional vigor. Something we call strict scrutiny. You have to be a compelling interest to make a law that will distinguish on the basis of race. But when it comes to sex and gender, it's what we call an intermediate scrutiny category, where it's recognized that there is a greater area for the state and institutions to distinguish between male and female, because these are natural distinctions that are important, in some instances vital to protect. So, for instance, we don't have bathrooms in the United States that say whites only or blacks only. That's illegal. But we have bathrooms that say men only or women only, and that's perfectly fine because there's a more relaxed review when it comes to sexuality and gender. And I just think it's a recognition, both historically in the law and philosophically, that
And naturally, right?
well, with philosophically
Oh,
drawing
and
on
naturally,
natural
right.
observations, right? That there is something fundamental to the human condition about male and female and the importance of respecting and protecting the differences in ways that in race, I mean, we should respect all races. That's not the point I'm making, but that
Right,
we shouldn't make distinctions based on racial differences
right.
in the way that we can allow for that to happen in the law. So I think this case was rightly decided. And it brings up, and I'll ask you this because you're done some study, especially on the religious history. Some people say that you can't legislate morality, but I think we do it all the time. But I think there's a helpful distinction found in the Ten Commandments that suggests what kind of morality we can legislate and what kind we can't.
Yeah, yeah, and I think there's and going back to kind of the theme of the podcast of the free church tradition, we see historically this interpretation in the Christian church, especially with the rediscovery of the validity of the Ten Commandments, a distinction between the obligations of each of the tablets. The first tablets have been understood, especially in the Protestant, in the Anabaptist tradition, as the duties that we owe to God, and the second tablets from commandments 5 to 10 as the duties that we owe to society, to our fellow human being. And that's something we see with, I guess, one of the heroes of this podcast, Roger Williams, who was very adamant to say that the state cannot enforce the first tablets. It cannot enforce a Sunday law. It cannot enforce blasphemy laws. It cannot enforce the obedience to a deity, but the state, it can enforce a public morality, and in fact it does, because public morality, it affects all of us. It doesn't affect merely our individual relationship to God, but it has personal and it has collective consequences to our society. So I think I also agree with you. I think this was a case where I think the Supreme Court, it acknowledged that the education of children has implications not only for um, the school, but also for society as a whole. And I also wanted to ask you, what does this tell us about parental rights or group rights? Is there anything we can kind of extract from this case on that?
Well, it certainly is a booster for parental rights. Um, I'm not sure how that necessarily relates to the notion of group rights. I mean, the group rights in this case were the rights of the community to educate in the public schools according to community values. These
Right.
parental rights are more in the form of individual rights. I mean, if you think of a family unit, the parent, the mother, the father, it's not quite an individual, but it is the elevation of at least family rights vis-a-vis the community, which is the school and the so I don't see. I guess could you argue that LGBT persons are individuals, and this could negatively affect their rights? I mean, there's a kind of balance between these religious family rights versus the LGBT rights to, be respected and appreciated in the community, and we think there's something to that. I mean, our church is part of the Free Church tradition, and it supported the Fairness for All legislation, which would have both supported LGBT rights in the workplace and in housing, but also the rights of religious organizations and businesses to run their organizations according to their religious principles. So we think that both sides can and should be
Accommodated.
respected. Yeah, we think the law can take into account both sides of this equation. But in this instance, it's the parents' rights. I mean, for me, this would be a different case if some public schools in a conservative area were giving materials to children criticizing gays and gay relationships, right?
Mhm. Right.
Disrespecting gays, that would be problematic as well, I believe. And
Because the public school has to be neutral, you would say.
I would say there needs to
Right.
be a neutrality here, sort of, because I'm happy with the public schools, talking about having, keeping sex for marriage as an ideal, because it's not just a religious ideal. There's lots of civil and social consequences with, promiscuous sex happening. But insofar as there are these moral religious choices, the state should try to preserve as best it can a neutrality.
How and just to maybe conclude this section, how do you see this affecting previous precedent involving cases of LGBTQ rights like Obergefell, Lawrence v. Texas, Romer?
Well,
Does this challenge any of that precedent or not really?
I mean, I think you have to see it as defining those rights in a somewhat narrower way than the LGBT community would perhaps hope for.
Right.
So when you combine this case with Masterpiece Cake
Right.
case and other cases like that, it's clear that the court is going to protect LGBT rights, but not at the expense of the
Of
rights of
religious liberty.
religious liberty and religious individuals. And I think that's something the free church tradition can support. But it also leads us into this third case, which I'm going to ask you about,
Oh, yeah.
because it also has to do with morality and children, the Free Speech Coalition versus Paxton. And it involved laws that I'm not sure what state was this, from Utah, because
Texas.
I know
This
there's
was Texas. Yeah, Texas.
So there's a Texas law that says if you want to access porn websites, adult entertainment websites with nudity and so forth, that you're going to need to put in a state ID that shows you're over the age of 18 before you can access it. And so there was a challenge to this law made that said this burdens adults' freedom of speech, access to protected speech. And the court below applied a rational basis test to this law burdening adults' access. And what did the Supreme Court say about this case, Guillermo?
Well, the court it decided that HB 1181, which was the law, it was the House resolution that was issued by Texas. And this law, it required age verification on websites with more than a third of its content harmful to minors. So if a website had more of a third of its content as adult content, the resolution would require that an individual show that they were that they were 18 or older. And the court said that the law, it stands, it passed the intermediate scrutiny test because it only incidentally burdens the protected speech of adults. So I think this is, I mean, and I want to obviously hear your legal analysis, but this was an interesting case because I think it kind of shows a little bit of where our culture is heading. And to answer your question as well, which is to a repudiation of pornography and to a recognition that there are morally harmful practices that can and should be that the state should interfere and regulate. And that was something that I think even the dissenting justices who tend to have a more maybe that would typically have a more libertarian stance on this issue, they also recognize the harmful effects of pornography. And I think that just kind of confirms something that we see and that we've talked about in the free church tradition, which the state can enforce the second tables of the second table of the Decalogue. The seventh commandment that deals with adultery, that deals with sexual immorality, is within the purview of the state, and it has a public morality emphasis on our society. So the state,
and especially, so sorry, finish the thought.
No, that was all I was going to say. So the state has a role to play in maintaining a healthy society.
And I think especially when it comes to children, right? That's what
Yes.
this case is about. This case, wasn't about stopping adults who wish to access it. It just it created a small burden in that regard. But the primary focus was on the protection of children, and so the court is saying when it comes to protecting children, if there's an incidental burden on adults in the process, we're going to allow that. And again, this is a case that underscores these issues of sexuality and gender don't draw the highest scrutiny; they draw this intermediate level scrutiny,
Mm.
and the state can at times, especially when it comes to protecting children, meet that standard. So that brings us to the closing section of
Yes.
today, where we talk about perhaps the misnamed big beautiful bill
Bill,
that
yeah.
passed by one vote yesterday. There
The
were
vice
enough
president.
Republicans opposing it that they only could get a tie, and the vice president stepped in and cast the deciding vote. Do we have any initial thoughts about this in relation to our theme?
Yeah, I think that the bill, it raises the question um, of what is what I guess it raises the question of what is our responsibility to maybe those who are the least among us. I think that was one issue that the bill has received a lot of scrutiny and criticism, which are the cuts on Medicaid, on Medicare that it is proposing. We know that these cuts, they will have an effect on a substantial portion of the population that depends on that. At the same time, um, to be fair, it also raises the question of how is the money being spent? Because the bill, it argues or it claims that it is addressing a mismanagement of government funds. So I think it raises some of these very important questions, which is how are government funds being properly administered, and how are they properly being administered to help those who are the least among us. So I think it's raising this very important conversation in our society today.
Yeah, I think it's hard to, depending on your political leanings,
Exactly.
you either hate this bill
Yeah.
or you think it's decent.
Yeah.
And it's not like there's some um, direct spiritual moral topic that's addressed by this in terms of days of worship or kinds of worship, but a lot of people do think that these cuts to Medicare certainly impact the horizontal moral framework of our lives and our communities and our nation. And yet, I saw some Republicans speaking in favor of this bill, and they said this bill will energize our private sector and it will bring more money to more people. And so they apparently legitimately think that this bill could actually help poor people and
Mm.
not hurt them. So, how do you enter that kind of discussion or debate, and make it a strongly moral issue? Well, we have a friend who we both respect,
Yeah.
that has done this. He's a pastor in our community, and I don't think he'll mind us naming him because he's already been
Yes.
named, or
As a
his
federal
photograph
government.
in the press.
Mhm.
Pastor Stephen Eric is a friend of ours, was a student at Andrews when I was a professor there, and he's now a pastor at the Tacoma Park Church, Seventh Day Adventist Church. And he was with a group of clergy persons, religious leaders, and other religious representatives on Capitol Hill, involving themselves in a protest, believing that these budget cuts were immoral in the way that they favored the rich and the way that they appear to harm the poor. And we actually received a report that they were carrying some coffins, symbolic coffins, burying justice and fairness, and they were going to bring them in front of the Congress, but the police stopped them, so they had to stop in the street, and apparently they blocked traffic, and he was actually arrested, taken to jail, paid a $50 fine, and was released. So Pastor Eric obviously thinks that there's some moral concerns here that a Christian leader should put himself out there, even to the point of civil disobedience, I will just say that Pastor Eric is in a fine tradition of American history. I was up in Boston, Massachusetts, about a month ago, and I visited Walden Pond, where Henry David Thoreau wrote his famous, some of his famous works, including On Civil Disobedience, when he was arrested for refusing to pay his taxes because he thought that they were going to support slavery. At least he was going to withhold the portion that related to that topic. So civil disobedience, even in the name of public policy and taxes and finances, has a deep and long-standing tradition in the American experience. And I think what we're going to do is try to get Pastor Eric on one of our next podcasts to talk to him both about his experience as well as his reasoning as a pastor and a Christian believer in terms of expressing that faith publicly and even in ways that may conflict with the law, as happened here.
Exactly. And if you want to see more of that and see our interview with Pastor Eric on our next episode, please stay tuned. Don't forget to like and subscribe to Fides et Politica. We really enjoy you here, and we can't do this without you, without your support. Nick and I are going to be this coming week at the General Conference of Seventh-day Adventists in St. Louis, where they're having their meetings, and we will also hope to be sending you some more content on that. So stay tuned for some more amazing content that we're producing. And please don't forget to like and subscribe and support us here online. Don't forget to follow us, YouTube, Rumble, Instagram, TikTok. And thank you for watching another episode of Fides et Politica.
And we'll see you next week in St. Louis. Until that, stay free and stay in the church.
Stay free and stay in the church. Bye-bye.